Welcome to literary and jury charge practice. Let's get started with this jury charge, and the subject is land condemnation. Let's give it a try. Ready? Ladies and gentlemen of the jury, this is an action on the part of the city to condemn certain land for public recreation purposes. Such land will be described to you in your verdict, which will be presented to you. To condemn land is to set it aside and apart for public use. The burden of proof in this action is on the plaintiff, the city of Madison. By burden of proof is meant the duty resting upon the party having the affirmative of the issue to satisfy or convince the minds of the jury by a preponderance of the evidence and to a reasonable certainty of the truth of that party's contention. By preponderance of the evidence is meant the evidence which possesses greater weight or convincing power. It is not enough that the evidence of the party upon whom the burden of proof rests is of slightly greater weight or convincing power. It must go further and satisfy or convince the minds of the jury before the burden of proof is discharged. The convincing power of evidence is not necessarily determined by the number of witnesses. It may be that the evidence given by one witness has greater convincing power than that given by several witnesses, contradicting or tending to contradict that given by one, though when all the circumstances are equal, the greater number of witnesses should carry the greater convincing power. In connection with these definitions, you are instructed that in determining the convincing power of evidence, you may take into consideration the knowledge, the source or means of information of the several witnesses, their interest or lack of interest, their candor or lack of candor, the bias or lack of bias manifested by them, the manner of testifying, the bearing of the witnesses upon the witness stand, and all the facts and circumstances that have been made to appear upon the trial. In this connection, you are instructed that the testimony given by expert witnesses who testified in this case as to their opinions is subject to the same rules or credit or discredit as the testimony of other witnesses. If you find that any witness or witnesses have knowingly and willfully testified falsely as to any material fact in the case, you are at liberty to disregard all of the testimony of that witness or witnesses not corroborated by any other credible evidence in the case. During this trial, various maps and charts have been introduced in evidence. You are instructed that these maps and charts were introduced solely for the purpose of giving you an opportunity to better understand the evidence which was introduced in the courtroom apart from said maps and charts. There will be but one question submitted to you. It reads as follows, quote, "Does public necessity require the taking by the city of Madison of the following described property for public recreation purposes in the vicinity of West Park Avenue, North 93rd Street, West Avenue, and North 95th Street in the 16th Ward of the City of Madison, County of Dane, State of Wisconsin, to wit, Parcel 6, all of Lot 19, in Block 7 of Vista Terrace, being a subdivision of a part of the southeast 1/4 of Section 29, Town 7 North, Range 21 East. Parcel 10, all of Lot 5 in Block 7 of Vista Terrace, being a subdivision of a part of the southeast 1/4 of Section 29, Township 7 North, Range 21 East. Parcel 11, all of Lot 14 in Block 7 of Vista Terrace, being a subdivision of a part of the southeast 1/4 of Section 29, Township 7 North, Range 21 East. End of quote. take a break there. That can be somewhat of a challenge, but good number practice, right? All right. Let's see what else we can do in the way of jury charge practice. All right, how about this one? The subject of this is rules of evidence. Ready? We are now ready, ladies and gentlemen, for the last chapter. In this case, we have been hearing for the last couple of days. These instructions I am about to give you are to be considered by you as a whole. In other words, no single instruction is to be weighed apart from the context of all of the instructions. In civil cases such as this, the affirmative of the issue must be proven. The affirmative here is upon the plaintiff as to all affirmative allegations of the complaint. Upon the plaintiff, therefore, rests the burden of proof of such allegations. In civil cases, a preponderance of evidence is all that is required, and by a preponderance of evidence is meant such evidence as, when weighed with that opposed to it, has more convincing force. Evidence must be either direct or indirect. Direct evidence is that which proves a fact in dispute directly, without an inference or presumption, and which in itself, if true, conclusively establishes the fact. Indirect evidence is that which tends to establish a fact in dispute by proving another fact, which, though true, does not of itself conclusively establish the fact in issue, but which affords an inference or presumption of its existence. Indirect evidence is of two kinds, namely presumptions and inferences. A presumption is a deduction which the law expressly directs to be made from particular facts, such, for example, as the presumption that a witness speaks the truth, to which I shall refer a moment later. Unless declared by law to be conclusive, a presumption may be controverted by other evidence, direct or indirect, but unless so controverted, the jury is bound to decide in accordance with the presumption. An inference is a deduction which the reason of the jury draws from the facts proved. In a case such as the one here presented, there is no legal presumption of negligence, but negligence is a fact which, like other facts alleged by the plaintiff, must first be proved by her to entitle her to recover. Therefore, I instruct you that neither the mere happening of the accident involved, nor the filing of the complaint, nor the fact that injuries have been sustained by the plaintiff because of an accident raises any presumption of negligence. In determining the credibility of a witness, you should consider whether the testimony of any witness is in itself contradictory, whether it has been contradicted by other credible witnesses, whether the statements made by any witnesses are reasonable or unreasonable, whether they are consistent with other statements, or with the facts established by other evidence. You may also consider a witness's manner of testifying on examination, the character of his or her testimony, the bias or prejudice, if any, manifested, the interest or absence of interest in the suit, the degree of intelligence, the recollection, whether good or bad, clear or indistinct, concerning the facts testified to, the inclination or motives, together with the opportunity the witness had to know the facts whereof he or she may have spoken. All right, now for some literary practice. And this is an article called Giving Back, and it's about a court reporter giving back to her profession. And this section of the article is called Getting into Captioning. Ready? I went to work at Vitek about 12 years ago. I was living in a rural area north of Pittsburgh and looking for more work. At that time, Kathy DiLorenzo, RDR, CRR, CBC, retired, was working with Merrill, and I came across her name in an internet search for national freelance agencies. I had lunch with Kathy, and she encouraged me to take a captioner's test at Vitek. It was decided that I had a good real-time base, so my husband and I moved back to Pittsburgh, and I went to work at Vitek in their Canonsburg office. It was the smartest thing I've ever done. The training and experience I gained there certainly helped me achieve the level of skill I have now. When I was in court reporting school, having not even graduated yet, I heard about the need for a student who was deaf at Carnegie Mellon. I quickly formed a company called Liaison for the Hearing Impaired and called Student Services there. I went there and did a quick demo and was hired on the spot. The funny thing is, I never wrote the classes. I wanted to be a freelance reporter, so I hired a fellow graduate to do the work. Wanda Proteau, a fellow cart provider, and I provided cart for the Pittsburgh Penguins for 5 seasons, completing our stint with the Stanley Cup. When I was asked to do the cart work for the Penguins, it was an easy yes for me. I would have done it for free. Since I had a captioning background, stadium captioning was an easy transition. I went to Stenograph to get training on my BCS software. I still had all of my sports dictionaries from Vitek, so with a little more prep I was ready to go. While I do still work in CART, the vast majority of my working life is freelance. I have started to explore doing more captioning CART work from home. I don't like to sit still, and I do like to be diversified with all my work. You never know what life will bring. Switching between the two is like roller skating. You have to remember you're not walking anymore and you've got skates on. I make the switch in my brain and in my job dictionaries, and I'm off to the races. It's very important to keep all of your skill levels up. If I told you what my typical week looked like, it would sound like I'm complaining. Let me just sum it up by saying I'm busy. If I'm not working, I'm marketing and training my staff and putting out fires. The freelance world is so very demanding now. Remember, I started this 30 years ago when a rush meant 7 days. Now, roughs are instant. I absolutely love this career. It has returned every ounce of energy I have put into it. We all know what we do is hard. I really do believe the rewards are worth it. And that concludes that article. Okay, now let's get back and do a little more jury charge practice. We'll get back to our jury charge on rules of evidence. Ready? Here we go. Discrepancies in a witness's testimony or between his testimony and that of others, if there were any, do not necessarily mean that the witness should be discredited. Failure of recollection is a common experience. Two persons witnessing an incident or a transaction often will see or hear it differently. Whether a discrepancy pertains to a fact of importance or only to a trivial detail should be considered in weighing its significance. A witness, as I mentioned a moment ago, is presumed to speak the truth. This presumption, however, may be repelled by the manner in which he or she testifies, by the character of his or her testimony, by his or her motives, or by contradictory evidence. If any witness examined before you has willfully sworn falsely as to any material matter, you may distrust his or her entire testimony. That is, being convinced that a witness has stated what is untrue, not as the result of a mistake or inadvertence, but willfully and with a design to deceive. You should treat all of such witnesses' testimony with distrust and suspicion, and you may reject it all unless you shall be convinced that the witness in other particulars has testified to the truth. A physician may be permitted, as was done in this case, to testify concerning statements made to him by a patient in connection with his effort to learn the patient's history and condition for the purpose of diagnosis and treatment. Such evidence is received and may be considered for only the limited purpose of showing the information upon which the physician based his opinions. These statements, so repeated by him, may not be regarded as evidence of their own truth, the reason being, as I think I explained, that the witness at the time he made those statements to the physician was not under oath or available for cross-examination by the other side. The rules of evidence ordinarily do not permit the option of a witness to be received as evidence. An exception to this rule exists in the case of expert witnesses. A person who by education, study, and experience has become an expert in any art, science, or profession, and who is called as a witness, may give his opinion as to any such matter in which he is versed and which is material to the case. You should consider such expert opinion and should weigh the reasons given for it. You are not bound, however, by such opinions. Give them the weight to which you deem them entitled, whether that be great or slight, and you may reject such opinions if, in your judgment, the reasons given for them or for any of them are unsound. In this case, there has been a certain conflict in the testimony of the expert witnesses. You must resolve that conflict. To that end, you must weigh one expert's opinion against that of another, the reasons given by one against those of the other, and the relative credibility and knowledge of the experts who have testified. Thereupon you shall find in favor of that expert testimony which, in your opinion, is entitled to the greater weight. All right, let's do a little bit of literary practice. The subject of this article is turn those failed tests into nailed tests. Ready? Have you ever failed a speed test even though you had enough words to pass it? If so, I have an idea that you can try. This will really only work with people who are dumping their notes or doing tests in real time. You need your CAT software for this tip. Even if you don't have CAT software, you can pluck out some of these ideas and just eyeball them yourself, keeping in mind that you want to be on the lookout for a specific detail. In my school, we take a test, dump our notes, and transcribe it. Most of my editing is done by scanning and/or search functions. This is very quick. 1, I do my normal scan stop through to correct any untrans. We are conflict free, but you can do the same thing for conflicts if you have them. 2, I read through for any punctuation that needs to be added or corrected. All right, we will finish that one up another time, and that will conclude our literary and jury charge practice.